Hi everyone, my name is Clara Hilger and I am a research assistant at the Law Commission in the Property, Family and Trusts team. And alongside that, I'm also a current final year PhD student at the University of Kent doing my doctoral research in law. And I'm going to talk to you about legal research generally and also specifically in relation to writing dissertations. And just to give you an overview of the next sort of 15 minutes or so, I'm going to talk about the overall process of writing a dissertation. We're going to talk about legal research and relating to sort of primary sources and secondary sources, how you find them, how you take notes on them, and choosing your topic, issues relating to sort of, whether you take a well-researched subject or whether you take a slightly less well-researched subject and the specific issues that come up with that. And then finally, there are some tips and tricks relating to note-taking and also citations that I'm going to cover very briefly. My colleague Lauren is also going to talk more generally about writing the dissertation. So I'm going to focus much more on research and note-taking and planning, and Lauren will take over actual drafting of dissertation and how that works. So in terms of what to consider when you write your dissertation, when you choose your topic and how to choose a topic, I think often this is one of the hardest things to do. I would really recommend thinking about what you've studied so far in your law degree and two main things: what you find interesting and what you, in terms of law, are good at. So it's very rare that a law student will be equally will find every part of the law that comes naturally to them. For example, for me, I found that property law came very naturally to me. That was a surprise. But when you choose your dissertation, think about what you've already studied, if there was anything that you found particularly interesting, any explanations to concepts that you didn't find particularly compelling and why, and choose an area of law that you're both interested in and good at, because writing a dissertation is difficult and you will make your life much easier by playing to your own academic strengths. Once you've thought about your area, you will do some basic research. So you will look at who else has written about your topic. You'll start reading articles, journals, researching case law, and you'll be identifying what's already been discussed. And ideally, you'll also identify not just what's been discussed, but what has not been discussed. After that, you will need to formulate a question, and that's your research question. And that's the question that your dissertation will attempt to address. What's very useful is once you've sort of got a broader question is to then split that question up into sub-questions. So questions that you need to answer in order to answer your question. And that often will form the basis of your dissertation plan. After you have a plan, and I will come to that in a minute, you will then write your dissertation. And that's something that my colleague Lauren will be talking about. You will probably have to do further reading as you write, and the reason for that is that very often it's only at the writing stage, when you're really trying to nail down your thoughts, that you realize there are gaps that you need to fill. Of course, the final part of any drafting exercise, any writing exercise, is to do your citations and to proofread. And in relation to that, I will come on to that a bit further, but the most useful thing you can do for yourself at the outset is to download a reference manager. I'll come to this a bit later, but people typically use either Zotero or EndNote. I use Zotero. Either will do, but I would genuinely say the very first thing you should do before you even consider doing any research is get your folders in order and download a piece of citation software, because it will save you a lot of stress and a lot of time. So in terms of legal research, how do we go about this? In legal research, particularly in what we call doctrinal research, which is where we analyze the substance of the law itself rather than its social consequences, your primary sources are legislation and case law. Your secondary sources are textbooks, books, journals, and blogs, and we will discuss those as we get to them. In terms of your own argument, case law and legislation are your most authoritative sources. The secondary literature may help you to understand the finer points in case law and help you bolster your argument. So it's not the case that you do case law research and legislation research and then you do secondary literature. It will often be a case of doing all of those things sort of, you'll do a little bit of case law and then you'll read some secondary literature about that case or about that piece of legislation. However, in terms of sort of practical matters, when you're looking at case law particularly, higher courts bind lower courts. So the appellate courts, Court of Appeal and Supreme Court, those decisions are more authoritative than the lower courts. It is very useful when you're looking at a topic that's sort of more current, that yes, there might be an authoritative Supreme Court decision and an authoritative Court of Appeal decision, but it's also helpful to look at how the lower courts, particularly the High Court, have looked at those decisions in much more recent cases. Those are not necessarily authoritative on the law, but they are useful in terms of figuring out how the law is being applied in the everyday cases. In terms of secondary literature, you should use secondary literature. So this is books, articles, articles from journals, blogs written by academics and practitioners. You should use these to further your understanding, and you should use them to further your argument. But you must be aware there will always be discourse, there will always be debate in the literature. Academics are rarely agreeing entirely on a particular question. So what you should not do is ignore the arguments and viewpoints of academics which disagree with you. What you should instead do is engage with those critiques and either acknowledge that there are different viewpoints and explain why those might not be persuasive or undermine them using your own argument. For example, Professor X's argument in ABC is unconvincing because of Y. It might not be taking into account certain new issues. It might be overemphasizing others. It might just be old, in which case new research might cast a new light on these conclusions. These are just some examples of why you might disagree with a certain argument in secondary literature, but you will have to analyze those arguments. What you should absolutely not do is ignore them just because they don't agree with you. In terms of another sort of good source, a good set of sources, I would say, is, of course, Law Commission reports. So the Law Commission, it's a very good place to start, particularly on issues of law reform as to like how the law can be improved, because that's exactly what the Law Commission does. And Law Commission reports typically have a very comprehensive overview of what the current law is. And, you know, they will comprehensively outline issues with the current law, and that can help sort of further and like direct research that you need to do. Hansard is a record of debate in Parliament prior to the introduction of new legislation. And the way you find that is by Googling Hansard. It can help you find out what the purpose of bringing legislation was. So it can help you understand what the sort of policy reasons were, and also the policy reasons against certain legislation, which can be very helpful. In terms of finding your primary sources, so this will be probably not news to you, but for case law, typically we will use either Lexis or Westlaw. I personally am a Westlaw person. Some people prefer Lexis. These are the databases that you use to search for case law. Other good databases are Find Case Law, which is run by the National Archives, Bailey, which is the British and Irish Legal Information Institute, Eurlex, which has all the European case law, HUDOC, which is for European Court of Human Rights case law, so the Strasbourg jurisprudence. And then some others that are not on the slides here are Canley, NZLey, and Ostley, and they are for Canadian, New Zealand, and Australian law, respectively. For legislation, you would use either Westlaw legislation or Lexis legislation search function. And we'll see on the next slide, there's an example there. The databases like Westlaw and Lexis will provide you with other information that is really useful to know without you having to do further research. So, for example, it will tell you if a particular provision in a statute is in force. And if it is a case, it will tell you if it is good law or whether it has been overruled or doubted or distinguished. And these are the kinds of pieces of sort of extra information that help you avoid basic legal errors, basically. So talking about a case authoritatively that has been overruled, for example. It's not to say that you cannot talk about that case, but it would be a mistake to talk about it as if it is good law. So this is an excerpt from Westlaw, this slide, and this is an excerpt from the Companies Act 2006. And as you can see, because this shows sections 414D to 422A, the Companies Act is a pretty sizable piece of legislation. It's very long. And this slide shows an excerpt from Chapter 5 about directors' reports. And you can see straight away from the green ticks that most of these provisions are enforced, but straight away you can see that section 417 is not enforced because you've got a sort of red no entry sign there. There's also an orange explanation mark on section 415A, and that indicates that the provision is either subject to an amendment or has got otherwise an explanatory note attached to it, and that means that that's something you need to check and look up. So this is the slide. So we've clicked on section 415, and you can see here on the sidebar that we're on the notes tab of this section. If you clicked on the text tab, it would give you the text of the provision itself. But the notes are really helpful. We've got here statutory annotations, and it tells you some sort of background information to this provision. So you can see, for example, this legislation, this provision was replaced, I should say, the Companies Act 1985, and it also gives you statutory definitions of key terms. So in this case, it actually says what's not excluded. So it says a deferred share in the meaning of the Mutuals Deferred Shares Act 2015 is not a share within the meaning of the Companies Act. So that's really, really useful background information if you were doing a project, for example, on the Companies Act, to know that, which definitions are being applied in which piece of legislation. And this is why practitioners and researchers typically prefer Westlaw and Lexis, because it gives you this extra information about the provision that can be really helpful. So in terms of finding secondary sources and for writing a dissertation at undergraduate level, master's level, you will be, unlike with problem questions where you are citing mainly case law and legislation, with a dissertation, you really have to take into account sort of academic argument. Finding secondary sources is often the most challenging part. And where you should always start is to conduct a search with your university online library catalogue. So if you're logged into your university account, you can search any relevant term. You can search, for example, they put here fraud, prevention of fraud, investments. You could search that put that into your university library catalogue. If you know the name of a particular article, you can search that and it will give you a link directly to the journal, and you won't have to do a separate sort of login. But I would always start with your university library. It will bring up books, whether there are physical copies in the library and electronic copies that they might hold. It will bring up journal articles. If you click the link, that will take you straight to those articles, wherever they may be held, typically JSTOR, Hain Online, Law Trove, etc. For Law Commission reports and for Hansard, if you enter your search terms into Google and then type Law Commission or Hansard afterwards, it will take you straight to there. And Hansard itself actually has a pretty useful search function as well. So searching for particular terms, particular pieces of legislation that have been debated in Parliament, it will give you results that relate directly to when that's been discussed in Parliament, and that can be really useful as well. Another really good option, which is not on the slide, but personally is what I do a lot of, is to use Google Scholar. So the way you do that is type Google Scholar into Google and it will come up with Google Scholar. And if you type in a search term in Google Scholar in quotation marks, you will a set of results of all of the people, all of the articles and all of the books that have dealt with that search term. And if you put in a Boolean, what we call a Boolean inquiry, which is when you put two separate related search terms into Google Scholar, it will come up with all of the articles that have dealt with two separate search terms. So for example, my PhD is on fiduciary relationships and in fiduciary duties and intimate relationships, and I needed to look at fiduciary obligations and restitution. So I typed into Google Scholar fiduciary relationship in quotation marks and then restitution in quotation marks, and it came up with hundreds of articles where this had been discussed. I think Google Scholar is actually a very useful search tool for secondary literature particularly when you're doing conceptual research. Once you've found some literature, the next method is called what we call the snowball method, or we call it follow the citations. So you'll start reading articles, you'll start reading abstracts, conclusions, and you'll go through and you'll see, oh, that was an interesting point, and there might be a citation there. And the best thing to do at that moment is to look at that citation and make a note of the citation as something that you're going to go and look up. And then, you repeat that process iteratively. Often typing the name of an article or a book in quotation marks and then putting JSTOR after it or Google Books will give you a quick link. Most research involves listing lots of articles and books. You will list all of these in your bibliography. There will be a lot of literature that you will look at and you will discard, and you'll say, okay, that's not relevant. You'll look at the introduction, you'll look at the conclusion, you'll look at the abstract, and you'll say, okay, this actually is not relevant, because things can look relevant on title, but actually not be relevant to your question. And the process of discarding sources is often just as important as including them. Everything that you search for in your research process should be listed in your bibliography, because it isn't a way for your assessors to see how your thought process and how your research process has gone. If you repeat that process for each article you read, what you'll find is that eventually articles will start referencing articles that you've already read. So you will start to get to what we call the bounds of the literature. And the moment this occurs is often a very happy moment in research, because it indicates that you've identified most of the core authoritative literature on the subject. That's not to say that you've surveyed all and everything, but you will by this point have identified the key literature. And that leads me neatly onto the next slide. What do you do when you research a well-researched subject? So some people find this quite stressful, because you think, well, everything has already been written on this. How can I possibly contribute? It's tricky for two reasons. Usually there's more literature to identify, and it's important to cite or at least put in your bibliography all of that core identified literature that I spoke about before. And so that research process can be more time consuming, simply because there's more to locate and identify. And it can be quite difficult to see how you will contribute to an area of research, because it may seem like the bases are covered. But if you've reached what we call the boundaries of the literature, and you've made notes and kept a record of the key themes that crop up, it's easier to identify where there are any gaps. And sometimes, particularly at undergraduate level, identifying that there is a gap in the literature can be the subject of a well-researched, high-quality dissertation. A typical conclusion, for example, in an undergraduate dissertation would highlight where more research needs doing. So often identifying that there is a gap and that warrants further inquiry, maybe by you and maybe by someone else, that can be a totally satisfying conclusion to a legal or law dissertation. With well-researched subjects, it's very good to narrow your focus even further. The example on the slide is from the Sexual Offences Prosecutions project. Sexual offences prosecutions is a huge topic. But for example, so let's say you wanted to do something on sexual offences, you could narrow that down by looking at one particular sexual offence, because there are several. You could narrow by time period, so you could say sexual offences in the last decade. You could narrow by geography, so you could say, okay, I'm looking at sexual offences in a particular area of the country or in a particular other country. You could even do comparative work, so you could say, I'm going to compare the way that England and Wales deals with one particular sexual offence with the way that, say, France deals with it, or so on and so forth. So those are often ways to narrow down questions. In terms of these tips, these are very good tips on the slide, and I suggest that you take a note of them. I will come to citations and reference managers at the end. Alerts and alerts on Westlaw and Lexis, that's something that I learned here at the Commission. I did not do that throughout any of my research degrees. I absolutely should have done. It is the best way to make sure that you are always up to date with any new literature that comes out, any new case law that comes out on your topic. And so I think once you've sort of identified your key themes and your key topics by narrowing down your research question, it's very helpful to set up alerts on classic search terms that you're always searching, either on Westlaw or on Google Scholar or on JSTOR or wherever. And that really helps you make sure that you haven't missed anything really significant between doing the bulk of the research and starting to write your dissertation. What do you do if you're researching a poorly researched subject? So often if you're researching something that's very contemporary, and the example on the slide is our research project on decentralized autonomous organizations, DAOs. These are a new type of social structure that trade in new types of currency, sort of non-fungible tokens and cryptocurrencies. And to publish this paper, the team had to look at research and authorities in other jurisdictions that had already looked at this particular problem. And the information in that literature was obviously very specific to those jurisdictions. So First of all, their case law and their authorities was not binding on us. The purpose of doing research in a new area is not to say this is what the law is or what should be doing, but to consider different models which could inform practice within this jurisdiction. So if you are more inclined towards theoretical work, and for example, that's as a researcher, that was what I was doing, a lot more theoretical jurisprudential work, then it can be quite fun to research something that's what we call poorly researched or new, right, where there's not much literature. But you have to be very careful when you're drawing your conclusions. Speculative and theoretical work has to acknowledge its own limitations. It has to acknowledge that what we're talking about is theory and not fact. And it will also require you to do theoretical research, which often comes from different disciplines, typically political theory, philosophy, social science, literary theory, and so on. So to give you an example from my own background, for my master's dissertation, I wrote about whether personal data could be considered property. And if it could be considered property, to whom that property might belong. To do that, I considered whether personal data could be property according to Hegelian theory of property. And to do that, I had to become very familiar with Hegelian property theory, because that informed a significant part of my research. My conclusions were speculative rather than definitive, so I argued that it could be possible under a Hegelian understanding of property to infer a property right in personal data, but I didn't come to any conclusions, because I couldn't come to the conclusion that data is property, because that would be legally untrue. So researching a poorly researched subject in many ways can be quite fun because you really can make a contribution, but you have to be quite careful about the extent to which you draw conclusions. And the nature of the research will often look very different. So you will be citing source material from different areas rather than just from law. In terms of note-taking, so I think the most important thing with note-taking, first of all, is to get organized. So as I said before, the very first thing you should be doing is downloading a reference manager. I use Zotero, it's the best. Other people use EndNote. People say that's the best. It doesn't really matter which one you use, they all do the same thing. It helps because not only does it help you do your citations, it also helps you keep a record of everything that you have read. When you open a book chapter or an article or any piece of secondary literature, the most helpful process is to read the abstract, read the introduction, read the conclusion. If in any of those things there's nothing useful to your question, discard it and move on. Repeat this process. If there is something interesting in that article, that would be an article to read. The best thing you can do for yourself is take good notes. Note-taking is very personal. People do it very differently. When I was an undergraduate, I was still handwriting notes. Now, obviously, we largely use, various different note-taking softwares. I use Microsoft Word because I'm old. And it really depends on how you want to do this. Some people really like to be organized and create tables and, summarize the introduction and conclusion, pick out some choice quotes, and then sort of put some text in to explain why you've read this and why it might be useful and why it might be interesting. I do what is not suggested on this slide, which is I have a running document where I put the article name and then I start taking quotes out of the article. But what I never do, and what you should never do, is just copy and paste without putting any of your own words against that quote. So without annotating the quotes from the article, it will be useless to you because you won't remember in 3 days' time or in 3 weeks' time why you copy pasted that particular quote into this particular document. So the most important thing is if you're going to take quotes from documents is to record the page number from the article. This helps with referencing. And then to add, it can be one sentence, a paragraph, but add something on your own thoughts and annotate that quote so that when it comes to writing your dissertation, you already have snippets of your own argument running through your notes. Note-taking is an iterative process. So you start by filtering through lots of information, and then over time you condense those notes into more specific usable notes. I find running documents helpful because you can use Control Find, but you can use that in a table as well. So when I come to write a chapter or write drafting, if I'm talking about a particular concept, I can Control Find that particular word, and then it will show me all the quotes which deal with that. And then I have a running page of all of the different articles that are relevant to this particular theme. But the key with note taking is that you must do what is best for you personally. People do this very differently. If you're not a table person, you don't have to become one to write a good dissertation, but you have to know where your information lies, and you have to know where the information from sources lies and where your own thoughts, your own information lies, and distinguish between those two things. I set up subfolders for key topics in OneDrive and make sure that when I download literature, it's already organized by topic. That allows me to use running notes because I already know what topics these running notes relate to. If you're not going to do that, then yes, I think organized tables are probably better. The last thing I'm going to talk about, and I know Lauren is going to talk about it more, is citation. So by far the most time-consuming but indispensable part of research. The reason for that is because if you don't do it, then none of your work can be credited because it can't be distinguished from work that derives from other sources. My advice, as I've said now several times, is to use the citation management tool. Download this as the very first thing you do. Keep a record of everything you read and download and intend to read in your reference manager. On Zotero as well, you can create, and I'm pretty sure you can do this on EndNote, you can create subfolders for key topics and themes, and that helps you keep track of which articles relate to which parts of your question. I think Lauren is going to cover this more a bit later, but for now I'll say some people cite as they write. So they'll start drafting, and when they know a needs citation, they'll then put that in and make sure that it's in the correct citation style and so on. Some people find that difficult. I'm one of those. And the reason is because it interrupts your flow of writing. I think general advice would be cite as you go. If you are someone who is not inclined to cite as you go, then advice from me would be make sure that when you quote and take notes that you are taking a note of the page number of the article or the book that you have taken that quote from when you take notes. So make sure that you, as you're doing notes, page numbers especially, that's very important. So, and it's also helpful when you're drafting to put a placeholder citation. So even if you don't put the citation in full at the time, putting a citation and then saying, okay, Wilson, page 7, lets you know that that is a sentence that needs citing. This is something that came from somewhere else and it wasn't your own argument. If you are also not going to cite as you go, the most important thing as well is to leave yourself enough time before the deadline to do all of your citations. Undergraduate dissertations can be anywhere from 7,000 to 12,000 words. To give you an example, when I did my master's dissertation, that was roughly 12,000 words. Doing all my citations at the end took me the better part of 3 days. So factor that in, because citation, unfortunately, is not a nice to have. It's a completely essential process, and it avoids plagiarism and other academic misconduct. So if you're going to do your citations at the end, just make sure that you leave, a good few days to get all of your citations in order and your bibliography in order at the end so that you can submit on time. And that's the end of my part of the presentation. And I'm going to pass you on to my colleague, Lauren.